Welcome everyone. It's a great pleasure for me to welcome all of you, also on behalf of the other co-organizers, Luca, Enriques, Casimiro, Nigro, and Tobias, Tröger. This is the third event in the Law and Finance of Private Equity Venture Capital series, co-organized by the LawFin at the University of Frankfurt, Bocconi University, the Department of Legal Studies, and ECGI. As you know, this series has the goal to explore how the legal framework can shape the ecosystem in order to favor the development of innovative companies, especially startups and scale-ups. And today we are focusing on research development that probably is the most important in the last decades. So the proposal about the 28 regime, or more precisely about the EU Inc., the new legal form for the European company that is object of this proposal of the European Commission, and now is under the examination of the Parliament and the European Council. Today, we would like to explore this topic from different angles. In the first part of the webinar, we will have 4 presentations. We will have 4 papers that look at the 28 regime from different angles. The first one is about the legal design of the EU Inc., and especially is about the ability of this new legal corporate form to meet the needs of especially innovative companies and especially venture capital-based companies. Then we have the second paper on insolvency, that is a key element of the proposal, but more in general, a key element of every ecosystem aimed at developing innovative companies. Then after a short break, we will have other 2 papers. The first one on basically on how the legislative process, also the lobbying activities, can shape this proposal and then influence. And then we will have the last paper that we try to answer one key question, basically whether the EU Inc. and the 28 regime can provide a legal framework capable to compete with Delaware, that, as you know, is the place where many European startups and scale-ups move in order to raise new finance. So that's the program. Then after the second break, we will have the final roundtable that is during which we can discuss some also policy option, or maybe to have a more general evaluation of the proposal. So this is the program. We have a quite busy afternoon ahead, and let me just inform you that this webinar will be recorded, and possibly will be the recording will be published on the ECGI website. So that's for your full information. But now, in order to keep the schedule, I would like to leave the floor to the first speaker, Casimiro Nigro, University of Leeds.
Thank you. Thank you very much once again. So good afternoon, everyone. Thank you, everyone, for being there. I'm presenting today some work with Luca, Enriques, and Tobias Tröger. The title is Templates in the EU Inch Regulation Proposal, and is forthcoming as an ECGI law working paper. The question we are trying to address in this paper is very simple. Do the templates for model articles of association in the proposal deliver for the very firms that the proposal itself was meant to serve? Well, our answer is that they don't, and I will explain you why in the next 20 minutes or so. So let me first tell you what our argument is overall. So this slide presents basically our entire paper. So as you well know, EU exists largely because of the venture capital industry needs, because of the needs of venture capital backed firms which cannot scale across Europe. The Letta report, the Draghi report, Commission itself, in its own startup and scale-up strategy, all converge on the same point. The legal fragmentation is a constraint on the financing of innovation in Europe. And the proposal is the answer to this problem, or at least is supposed to be the answer. And it builds on that discussion regarding innovation-driving firms, but it is definitely uncalibrated to those firms, as Luca, Tobias, and I have explained in a long Oxford Business Law blog post just one day after the proposal was published. What we are adding to what we are adding through this paper is basically that we are focusing now on one specific aspect of that mismatch, because the core device, one of the core devices on which the proposal builds, which is a statutory template for the article of association, is actually very revealing of that mismatch itself. So the question is simple. As I told you, the question is, do the templates support the contractual technology on which venture capital financing depends? The answer is no. There is a misfit, which is structural and it's 4-dimensional. We therefore advance 4 correctives that might help actually improving the status quo. I will now unpack these points one by one by telling you how the proposal approaches model documents, what venture capital contracting requires based particularly on our prior work on the matter, and what the concern the proposal raises and how we think that we can address them. So let me first of all go very quickly, since this is the first presentation, through the policy trajectory with a view to specifically unveiling how model documents have evolved throughout the policy making process. So the Letta and the Draghi reports were airing the idea of an optional corporate form, but like the subsequent stages, including the UE, Inch campaign and startup and scale-up strategy of the Commission, they didn't mention the model documents. The Rapazzi report actually did. That's when model documents appear, and the idea there was that there should be model article of association, shareholder agreement, a model shareholder agreement, and that both should be drafted by 2 experts groups. The Rapazzi report also included the idea that the templates should be informed to an idea of fairness. And at the same time, it didn't really mention at all any safe harbor. The templates would be optional. Contracting parties could opt into using them, but there would be no safe harbor, no sort of protection from any from potential invalidities at either the formation stage or later on at the litigation stage. The Parliament's resolution then endorsed entirely this approach, but then in March of this year, as you know, the Commission proposal arrived and the proposal changed approach quite radically and unfortunately for the worse. The proposal actually dropped the model shareholder agreement, dropped the 2 expert group drafting architecture, and it retained the fairness mandate. The one substantive feature that actually added was the safe harbor, meaning that if contracting parties use the model documents, the model articles of association, they will benefit from all the legal requirements at the national level will be deemed satisfied. This safe harbor, however, operates only at formation, and even that, if one reads carefully the proposal's wording, is not to be taken for granted. So instead of elaborating on the input of the Rapazzi report to refine the templates architecture, the proposal somehow implemented a sort of selective retreat in the approach, coupled with a small addition, which is this safe harbor I just mentioned. So what is actually, as of now, under the proposal, the regime governing the templates, the template for model article of association? So first of all, the model article of association are to be an annex to the regulation and are to be drafted by the Commission by future implementing acts. There is no shareholder agreement, and firms incorporating as EU Inch may adopt the model articles with the model articles, of course, falling under the regulation regime, but with member state law governing anything left outside of the model articles of association, for instance, shareholder labor arrangements. What does the contracting party's choice decision to use the model document results in? Well, it delivers some formation stage benefits. As I pointed out, it leads to deemed compliance with national form and certification rules. It leads to a fast-track incorporation process, but preventing control by notaries and registers are preserved. So what after the formation? Well, after the formation of the common, the proposal is silent. Courts and in general adjudicators, including arbitrators, would be likely to be able to strike down a clause or recharacterize it, and certainly would be able to second guess the way in which contracting parties can exercise their rights under abstract notions of fairness, through good faith clauses, for instance, that do not align well with the specific implementation logic of VC contracting. Although the fairness feature that was in the Ropasi report and the European Parliament resolution was not explicitly retained as a feature of the model templates themselves, the regulation still designs a general corporate law regime that puts mandatory minority protection devices at the center of it. So this is going to likely also affect the way in which model documents are conceived, and also because of other features in the corporate law regime itself envisaged by the proposal. So if this is actually what we have, let me tell you what we have found in our prior work about what venture capital contracting needs in order to operate properly in Europe. Later on, we will assess against this benchmark what actually the concerns of the proposal are. So first, as you all know, VC contracting is a specialized technology. It's not just a corporate contract with some adaptation. It is a contract that has its own functional logic, and that logic, if it is to work, does not accept compromises that results in low power incentives for the entrepreneur or in the inability of the venture capitalist to take most, if not all, of the value of the firm when there are so-called sidelined venture capital backed firms. The specialized technology doesn't live in one or just the articles of association of the shareholder agreements. To the contrary, as you can see from these slides, it's actually the combination of both articles of association and shareholder agreement, one or more shareholder agreements, which are not only functionally integrated, but also mechanically mutually supportive. For instance, the article of association provide, in particular, the article of association provide for the institutional backbone that makes sure the shareholder agreements can also be enforced within the companies without resorting to external enforcement at all. So in practice, the articles of association are important because they do the need that needs to be done with erga omnes effect. But the shareholder agreement also are key to ensure that some specific provisions can be made with the right level of confidentiality. So there are reasons why the specialized technology that supports venture capital deals is distributed through two different instruments. And the allocation across these two instruments is not accidental, it's deliberate. In principle, the deal structure, this structure I just described, like its content, reflect presumptively value maximizing choices. So let me tell you also what actually this technology is in terms of content from a design perspective. Ex ante, it is very well known that VC contracting allocates, as you can see on the left side of the slide, allocates a disproportionately cash flow and control rights to VC investors, and ex post this might lead to a sharply uneven distribution of firm value when downside risk materializes in other key scenarios. I'm talking about down rounds, liquidations, forced sale, whether small tug exit transactions or so-called fire sale events. So within the VC contracting technology, asymmetry is not just a defect, is not a pathology, is an agency cost minimizing design choice, which has, of course, value. Is where the value of the contractual technology lies, actually. Okay, so sophisticated parties accept the asymmetry structure not because they cannot do otherwise, but because, from the perspective of entrepreneur, this lowers the cost of capital, and in a sense, asymmetry here is the bargain itself, is not a pathological deviation from what parties would have bargained under other circumstances. However, as we have shown in our prior study, if we consider what stands in the way from a corporate law perspective in Germany and Italy, like perhaps in other jurisdictions, of the implementation of the presumptively efficient contractual technology, we find that there are two main obstacles from a mechanical perspective. On the one hand, ex-ante legal keepers, counsel, notaries, registers might block, dilute, or refuse provisions that they read as incompatible with prevailing interpretations of corporate law, making optimal arrangements or their functional equivalents unavailable, and compelling parties to take inferior alternative arrangements. On the other hand, ex post, courts and arbitrators, adjudicators in general, might narrow, recharacterize, or invalidate the clauses they slip through and that they eventually make into the corporate contract. Plus, they can second guess how rights are exercised against a fairness baseline that is fundamentally alien to the logic and financial economic, to the economic and financial logic of the deal. While we document this friction with regard to Germany and Italy, this friction is likely to be more general. And there is evidence that, although it's fragmentary, there is evidence that similar dynamics are also detectable in other continental Europe jurisdictions. For instance, Paul Odin provides evidence in that respect for France. This matters, and Enriques confirm it, because this is supply sensitive to the legal environment in which actually the contractual technology must operate, as regards both the availability of the clauses and the exercise of the ensuing rights. Where the law impedes the technology to operate as it should, the cost of funding raises at the margin, and it might actually lead to the inability of entrepreneurs to access VC financing. Okay, so now based on this, let me tell you what the problems that we found in the proposal. There are four problems, four concerns. One is scope, the other one is process, the other is contractual logic, and the fourth and last one is the safe harbor. Okay, so first of all, as I pointed out before, the scope of the proposal template is too narrow. Articles and shareholder agreement are mechanically and functionally coupled, and neither works alone. But unfortunately, the proposal provides only for model articles of associations. So the shareholder agreements needs the article for institutional backing, and the articles need the shareholder agreement for a number of substantive terms they support, which end up in the shareholder agreement because, for instance, of confidentiality reasons. Delivering alpha template like the proposal does by providing only for articles of association is incoherent on its face. The problem is not, it's conceptual, it's functional, it's mechanical, because the two won't work alone in any effective way. And it precedes any positive law issue, but there are also positive law issues, because shareholder agreements left to member state law might basically lead to the situation where firms registering in jurisdictions where corporate law is unfriendly to VC contracting, such as Germany. So the shareholder agreements might end up falling under local corporate law, and the constraints that we documented are applying to a shareholder agreement would apply fully. Second, and the second problem is the process. Under the proposal, drafting moves from two experts groups to a generalist consultation run by the Commission. The risk is that there might be a template which will just be a compromise, and this might not serve the VC backed firms that actually the proposal was intended to support. Third, there is an issue with the contractual logic of the model articles of association that the proposal provides for, because the proposal takes a fairness posture towards, although indirectly, towards model article association, and this is incompatible with the contractual logic of VC contracting, which is asymmetric ex ante and might lead to asymmetric allocation of value ex post. So abstract fairness as an organizing principle clashes with the economic logic of VC contracting very radically. Fourth, there is a problem with the safe harbor, which the proposal currently provides for, because it's actually about only the formation stage, but it doesn't say anything about what happens when the clauses in the templates will possibly be litigated. So we basically bring in four suggestions, which are the following. First of all, the templates should be, the shareholder agreement should be restored. Secondly, there should be a dedicated drafting track. The templates should be taken out of the generalist track, and a specialized body as Luca and one solo piece argued, should be perhaps be should be responsible for implementing, for designing, for drafting these templates. The templates should not be informed to any external abstract idea of fairness. They should basically be designed in a way that is consistent with the logic of VC contracting, and those that are actually outlined by the National Venture Capital Association in the US might be a reference point, even though we don't argue that they should actually be copied entirely. Fourth, the safe harbor should extend beyond the formation stage and make sure that there are both specific provisions that govern the formation stage, plus specific provisions that actually make sure that the clauses in the templates are valid and that the adjudicators will assess the exercise of the rights ensuing from those provisions in a way that is consistent with the logic of VC contracting. So some meta rules, some interpretative rules are required to the end to fence off the application of general clauses such as good faith. Well, in a sense, Ringe is the clearest acknowledgement that corporate law shapes the VC market, as we have been arguing for 5 years now. But if the templates miss the very firms that made the case for Ringe, the regime then ends up as a procedural fix from a very heterogeneous population of unlisted firms and little more. Is that what the EU wants, and above all, what the EU needs? Well, we doubt it, and that's why we think that model documents should be reconsidered along many dimensions. Thank you for your attention, and I'm happy to take questions.
Thank you very much, Casimiro. I think that this paper focuses on key aspects of the proposal and probably one of the more controversial aspects, but of course I abstain from any comments. I will immediately leave the floor to the discussant, Marco Darin, Tilburg University. Marco, you have 10 minutes for your remarks.
Okay, thank you for the invitation to discuss this very interesting paper. So this is kind of a very interesting paper. So kind of what I wanted to say is that the key message of the paper is a summary of why the proposal arose, which I found very interesting in terms of providing a good context to understand the development. Identification of 4 limitations and suggestion for remedies, and Casimiro has done, I think, a very good job in summarizing them with very nice slides. I really like those. So the 4 limitations, just kind of repeat and build on that, kind of reduce scope of the regulation in the final version, only articles of association and no shareholder agreements, and that's a problem, as he argued, that because the two are clearly building on each other. Hollowing out of the VC relevant contingent contracting approach, and the issue of whether kind of the regulation can sustain this contingent contracting even in its final form, and the fact that the safe harbor effects may fade out. And so the 4 remedies restore the scope, so include shareholder agreements in a revised version, create a dedicated drafting track which can include VC friendly or VC relevant clauses, eschew fairness in the templates. That's kind of a fairness really seems to be something which has been kind of pushed into the proposed regulation, and extend safe harbor provisions beyond formation throughout the life of the startup and hopefully the scale. So I think this kind of, I found the paper to be very neat and very clearly exposed. It builds on previous work, which which actually it's a very nice thing because brings you to read. I was aware of only one of those previous papers, but I mean that it is a coherent and very interesting, let's say, research agenda that they have developed over time. Now I have kind of I want to bring a couple of type of comments. First of all, kind of I raise kind of a couple of concerns. It's not really concerns, but things that I think somehow limit a little bit the scope of the paper. And then I will bring in some kind of ideas for further analysis, trying to kind of provide a slightly broader perspective on this issue, which is not a criticism to the paper itself, but kind of just to say that I think we should kind of have a broader view to come to a full appreciation of the difficulty also of these issues. So kind of the few concerns that I have is kind of clearly the paper is very history dependent, which is good in one sense because it gives us a very good perspective and way to understand it. But at the same time, kind of I think I know that it remains relatively unambitious in the sense that it takes all these path, all this development as given, and in a way doesn't kind of dare to think what could be kind of an alternative world, okay, or an alternative regulation in that sense. So in that sense, kind of, I felt a little bit limited in the type of proposals which were put forward because they were kind of taking the overall structure as given, okay, and in a sense, I found it a little bit kind of dirigist in the sense that it has a very in this sense kind of a very European view. Okay, let's put together the stakeholders, let's make them talk, and that will give us kind of a good solution. Okay, part of it is true, but kind of clearly we also know kind of, and I think that there is another paper later on today which deals with this kind of that there is a lot of lobbying and influence from stakeholders or states or different subjects, and so that I also kind of found something which kind of I would have kind of made less stringent in the writing of the paper. But I mean, as I said, it's a great reading in terms of understanding what is happening. And in the last kind of next, I think I still have 4 or 5 minutes. Let me just try to, in that sense, provide a kind of an extension, a slightly different and broader perspective. This is clearly kind of what the paper also makes clear is that this is not really a 28th jurisdiction. It is kind of a pale image of that. It's something which tries to provide some responses to concerns that have been raised over time and have been crystallized in the Letten and Draghi reports a couple of years ago. And so it focuses on startup formation more than growth. Okay, and we know in a way that kind of the empirical evidence tells us that clearly creating startups in Europe is not easy, but it's not the first order problem. The first order problem is to scaling them up. And so in that sense, the regulation itself, it is aimed at a relatively secondary problem. It leaves out many aspects, for example, labor and bankruptcy issues, which are not considered within the regulation, and it embeds then the life of the startup in national systems and their legal structure. So they would have 1 foot in the EU and 1 foot in their home jurisdiction, and so in that sense, this really fails to be a 28th jurisdiction. Given this kind of, which companies need this? And I said, it's not so much the startups, at least not as a first order issue, but companies that need capital and that want to operate cross border and now often emigrate because that makes it easier. And this revolves again around this issue that the Latin Draghi reports make clear, that Europe is a collection of markets, but it's still not a common market. Whereas if a successful scale-up moves to the US, the US
Sorry,
is,
Matt, just
yeah.
to let you know that you have still 3 minutes, more or less.
Sure. Yes. Don't worry. I'll be there. Thanks. And so, and the other thing which I want also to stress is that the analysis should our analysis of this issue should also consider the fact that many companies are not even created now. So we are worried about allowing the scaling up of successful startups, and that's very good, but it's even deeper, the issue, because many companies are not created because ambitious entrepreneurs may just emigrate in the first place or just choose not to create companies. And so there is this fundamental tension between the national and the European dimensions, which is something which touches a lot of European issues. And this is I think it's a case where this is also very, very, very important. And so can we get away with it and achieve some goals? Or are we bound to imitate the US? In the sense, some of all these proposals tend to imitate the US, and a lot of this is clearly very good. Okay, like the functionality of the contracts should be what we observe in the US. No reason about that. But could we also think about creating a framework that allows some experimentation, which allows for a solution which is not just transposing US principles here? So one way could be to go for a fully fledged independent 28 jurisdiction, let's say European virtual Delaware, that accounts for all aspects, including, for example, labor and bankruptcy, and isolates these startups which may become scale-ups from national jurisdiction. Another very different approach could be to plant the seeds in one actual jurisdiction, and I say, why not the Netherlands, being academically based there, in the sense that the Netherlands is a good example of a country which has created a regulatory and also legal and organizational system which is conducive to headquartering companies there. Part of that is based on taxation, but I think it's a possible blueprint for something which is more of a European Delaware, where agents can also experiment in a testable market and develop contracting and contracting solutions to achieve efficient outcomes. And the 1996 Blue Sky laws overriding the US, in a way, it's an example which tells us that maybe that direction could be feasible as well. And clearly, and this is my last point, is the fact that we should not think with a status quo in mind, but we should take as our goal the fact to really help create a European-wide market for scale-ups and in that sense for capital, especially by allowing some experimentation to reach a viable legal framework. And in that sense, the EU industrial structure and its working, it's determined by the fundamental lack of competition, and that's one of the issues which needs to be taken into account. And finally, just a postscriptum, there is a danger of thinking about inorganic reform. So we reform one piece, one tile, and we forget that that Europe is a body which works fully, and so we need to in that sense, take a broader view. But clearly, this is not kind of a criticism of the paper. It's just to try to provide kind of a broader economic perspective on it. And I really encourage everybody to read this paper because I think it's a great reading. Thank you.
Many thanks, Marco, for your insightful discussion. And now we have 10 minutes for the Q&A session. And maybe I will ask Casimiro if he wants to react briefly to the Marco comments, and then we can open the floor for the question from the participants.
Thank you, Giovanni, and thank you, Marco, for your comments. Actually, yes, we somehow take the approach you pointed out, and we might want to refine that somehow. But the starting point for us was the proposal as it is now, and we will have to see whether a more dynamic conception of the regulatory framework might be appropriate to think about the model documents. That's the main reply I have for Marco, and I'm happy to take other questions. Thank you, Marco, once again.
Sure.
Yeah. Now we can open the floor. Maybe you can raise your hand. Yes, we have the first question. Georg Ringe, please.
Hello. Yes. My question to you, Casimiro, is to what extent do we really ultimately need templates that have been proposed and prepared by legislators, as opposed to templates that will be drafted by the industry itself, right? Because, I mean, as you rightly point out, this industry really has its own inherent traditions and expertise, which is unmatched by any civil servants, let alone somebody who has, as you say, the idea of providing a fair, balanced proposal, which ultimately will not be accepted then by the industry, right? So the question is, do you think the dysfunctional templates that we see emerging in the proposal will then be marginalized in a way and substituted by something that the industry provides itself?
So thank you for your question. I think actually it's two questions: why we need templates, and then what happens to templates that are dysfunctional. So I will address them both. On the one end, I would say that we need templates, at least based on our prior work with Luca and the prior work on venture capital contracting that I did with Luca and Tobias, because that's one way of insulating private ordering solutions from interference from legal gatekeepers ex ante and adjudicators ex post. So templates are the answer to the specific friction we detect when it comes to the obstacles that mandatory corporate law creates in Europe. Of course, we would not need them if market participants could themselves find the best way they can to address the market frictions that actually bedevil the financing of innovative startups. But unfortunately, in a highly interventionist legal world, where legal gatekeepers on the one end, and if not they, then adjudicators ex post will somehow reconsider the validity or other aspects of the contractual technology envisioned by market participants, then legal templates can be a solution to that problem. So that's basically what I would call the shielding function of templates. So that's about the first question you posed. The second question instead is whether they are at risk of being marginalized. Yes, of course they are. Ossification risk is one of the risks we detect in this paper, and we mentioned that there would need to be some sort of regular updates, which is actually what happens also in the US under the approach that the National Venture Capital Associations take to model documents. And yes, they would definitely be marginalized. They would be of no value whatsoever if improperly drafted. That's why one of us, Luca in particular, actually argued that market participants should be involved. We also argued, but he actually suggests that the drafting function should be actually externalized to the Invest Europe or other similar organizations which might be best positioned to address the risk you are pointing out, and best position to deliver templates that might actually meet the real needs of the market rather than just being the function of a commission-led drafting process. So that's my answer to your questions. I don't know whether I addressed, but I hope so.
Yes, I think that we have 3 minutes for the last question, and Hans de Wolf can ask.
Hi. Let me first give a positive comment on Casimiro's presentation. I think the idea of extending the safe harbor to the templates after the company has been set up is a very good one and a crucial one to make any type of 28 regime work. Without that, you will get 27 different regimes that will be undermined by local judges and national legislators. So I think that was a very good proposal. But my question to Casimiro is whether you think it's realistic to have a template about shareholder agreements. My feeling would be, but maybe your research on American VC points in a different direction, my feeling would be that whereas I do believe in standardized articles of incorporation, I think shareholder agreements need to be tailor-made for every single company and investment round, and it's not realistic to produce templates for shareholder agreements. But you probably disagree. Thank you.
Well, thank you for your question. Actually, I think that the rationale is the same for shareholder agreement and for articles of association. You would need, in principle, then the specifics of each firm and its own needs, tailored articles of association, tailored charters for each firm. But that's exactly what we cannot have. Model articles might be a second best option, but still, they might be better than tailor-made articles of association, which are exposed to or ex ante corporate law-based constraints. And I don't think that the story changes when it comes to shareholder agreements. I mean, there, of course, you also would need to have tailored shareholder agreements. But tailored shareholder agreements are not possible because of those constraints. So I think that extending the same solution we have for articles of association to shareholder agreement, although it's not optimal, or at least not the best option, it's a viable one. So I think, again, that we are not talking what we could do and what we would do in the ideal world, talking about what we could do in this world where legal constraints exist and we have to take them into account and find a way to counteract them, or possibly, if not mitigating them, at least address them somehow. I don't know whether Tobias and Luca want to add something. I'm happy to, of course, hear their voices as well.
Just very briefly, I think on the idea of having bespoke shareholder agreements, I guess that in early funding rounds like seed, Series A, Series B, the stuff is pretty standardized because that's not really something that you really negotiate the terms of these shareholder agreements. And you can say that and if you talk to venture capitalists, they will tell you that there are some things that we definitely need and others are nice to have, but not essential. And therefore, I think like Casimiro rightly said, if you have a trade-off between standardization on the one hand with insulation against judicial interference and bespoke shareholder agreements without any protection against ex-post interference, then maybe that's not such a bad choice.
I don't know if Luca wants to add something. So now I thank Casimiro and Marco in particular for the presentation and the discussion, and we now can move to the second paper, so to insolvency. That is another key aspect of the proposal, but probably also one of the critical aspects of the proposal. So the floor to Georg Ringe, University of Hamburg.
Yes. Hello, everyone. It's very nice to be here. Thank you so much for having me at this conference. These online conferences or workshops remind me always a bit of the COVID time, but I acknowledge that there is some benefit in discussing very current issues and bringing together a pan-European audience. So it's great to have this large group discussing the EU Inc. regime. So my paper, it is trying to widen the perspective a bit and is looking at insolvency law, not just in the 28th regime form, but also the parallel trend to harmonize insolvency law, because these two approaches happen at the same time, which is somehow very surprising. It has been a long push, actually, in the insolvency world, a long debate on reaching further integration, reaching further harmonization at the insolvency law side. And the Letta and Daghi reports have said this. the Capital Markets Union idea has repeatedly said we need common rules on insolvency across the EU to better price risk for lenders, for creditors. And institutions like the IMF, like the ECB, and countless others, think tanks, NGOs, they've always been saying this. And so very recently, just a couple of weeks ago, actually, the EU agreed on an harmonization directive, which was adopted at the end of March 2026. And it's partly harmonizing some aspects of EU insolvency law. And interestingly, at the same time, this 28th regime has come up, as you all know, and as we've just been hearing, that the EU Inc. proposal was also published in the same month. And it's focusing, as you all know, much more on the corporate legal framework. So it's providing a common framework for company organization, for internal arrangements for corporate governance. But it also has a few aspects on insolvency law. So what I want to do is to connect these legal developments with the economics and with the politics behind those two initiatives to explore the relative advantages and disadvantages of the two approaches. Let me first say a few words by way of background. Where are we in insolvency law in Europe? The original approach that was pursued by European institutions was actually very different. It was not a harmonization approach at all. There was just an approach based on conflict of laws. So to say we need one common idea of where pan-European insolvencies are being filed, the famous COMI approach, and we need to have a common approach and common understanding of which national law applies. But we leave the substance unaffected. So each member state still has a completely separate regime. And that approach has worked to some extent, but of course it led to some arbitrage possibilities, forum shopping, moving around for the most attractive insolvency regime, and ultimately some regulatory competition. And after that, the European Commission has harmonized some bits and pieces here. Just remind you of the directive on bank resolution 2014 in the wake of the financial crisis. And we also have 2019 a restructuring directive, which is trying to harmonize restructuring mechanisms, but leaves many, many loopholes and really isn't a full harmonization, I would say. So that approach of getting closer into substance hasn't really worked out so well. And it just became stronger, and the push became stronger in the light of the Capital Markets Union idea. This is just to give you the background, the pet project of former Commission President Jean-Claude Juncker, who came with this slogan into office in 2014. And it was his baby, essentially, to facilitate cross-border investment and to make it easier to harness financial possibilities across the European Union. And one thing they've always been saying is that insolvency is super important in this because lenders will be discouraged from lending across borders if the insolvency regime is unclear to them. And that was the intellectual background for saying we need a common standard, a common understanding of what the legal position of creditors is in an insolvency, and that will facilitate greater cross-border investment. That project made some baby steps into further capital markets integration, and von der Leyen took this project up herself, also made some small steps in progress, but I think hasn't really yet seen any major breakthrough. Brexit, of course, didn't help. COVID-19 didn't help. And in her second administration, von der Leyen has rebranded CMU as Savings and Investment Union, but essentially with the same objective. So ultimately, the European Commission was successful in adopting a directive in March, as I was saying, on some aspects of insolvency law. And this is supposed to be implemented by 2029, right? So still some time to go before this really takes into effect across Europe. Just to give you a flavor of the substance, it harmonizes rules on avoidance actions, It introduces pre-pack proceedings and harmonizes to some extent filing duties, right? So to what extent are companies obliged to file for insolvency, and some common rules for creditor committees. The really interesting question then is that really a sensible approach, right? And the case in favor is, as I have hinted at, the idea of facilitating the internal market, the transaction costs argument. If I am a bank and I'm lending to borrowers across the EU, I have 27 different regimes to find out what is my position in a potential insolvency of that borrower. And the idea is, if you have common rules, ideally, of course, completely, fully harmonized rules of insolvency, then I would be much more willing as a creditor to make a loan across the border. So in other words, what they are trying to do is to facilitate risk pricing in cross-border transactions to make things more foreseeable. The deeper point, of course, is to create a level playing field across Europe so that companies, borrowers essentially, can compete on economic grounds. And they wouldn't get a better term or a better deal or a better loan, not just because their legal regime is preferable, but because their, financial situation is stronger, their business plan is better. And finally, this idea is seeking to reduce arbitrage and competition that I was talking about. Because if you have a common standard across Europe, then of course there's no incentive to arbitrage around to forum shop for an attractive legal regime. That's the story that's been heard across the EU from many institutions so far. I want to pour some water into the wine and bring a few question marks behind that story. One point, I think, is the one size doesn't fit all point. Right? So we have and still have a great variance in economic conditions across the EU. For example, creditor concentration is very different across EU member states. Germany, for example, is characterized by a very heterogeneous banking sector with not many big, large banks, right? More smaller local savings banks and other local tiny banks that lend to the German firms. In France, characteristically, we see much larger banks dominating the landscape. And why I'm mentioning this is you have to understand that the insolvency rules have to match that banking structure. So if you have creditor-friendly rules, strengthen the position of creditors, that makes a lot of sense in the German context, but not necessarily in France, right, where they are already very powerful in bargaining with lenders. And now if you introduce one common standard by a common directive, then the risk is that you have disproportionately different effects across the EU. So for example, if you take the new directive that's just been agreed, the rules on avoidance actions are actually very similar to the German standard, and they are relatively creditor friendly. So they make a lot of sense in the German context, but really wouldn't be functional in France. So my point is that a common standard across the EU will have very different effects depending on the country that it's supposed to operate. The second point with any harmonization project is the harmonization dilemma. Which of the 27 standards should the EU choose to become the number one standard at Europe? Right? And that is, as we've just seen in this project, and also as we're seeing in the EU Inc. project, is up to a lot of political bargaining. There's nothing worse than the big lobbying bubble in Brussels, where they are really trying to influence lawmaking with a lot of national interests in mind. So it might be that lawmakers end up with a maximalist standard, right? So picking the highest, the toughest of all 27 countries. But it might also be that they cannot agree on anything and choose the lowest common denominator. Or just the one where the strongest political reason speaks for something, or where the most powerful country is influencing something, or where you just get a deal, right? I, country one, agree on your proposal in insolvency, and then country two agrees next week on your measure in agriculture, for example. So it doesn't have anything to do with the substance at all. Third problem is that any harmonization undermines the virtues of regulatory competition. We know, not least from people like Friedrich von Hayek and others, that competition between countries, regulator competition, is a helpful and healthy exercise because it leads to experimentation and may yield an efficient outcome. So countries have an incentive to be better than others, to provide a better restructuring regime or a better insolvency law that is performing better and giving their local firms an advantage over others. In contrast, if you have one uniform standard from Brussels that de facto is a legal monopoly that countries cannot change anymore, and has all the problems with it, that, it might run into overregulation, standardization, as I said, despite underlying differences, increased complexity, and also the problem of reduced adaptability. So by all means, right, we've seen this countless times. Once people have agreed something in Brussels, it's super difficult to change it later on. Once it's there, it's almost set in stone, and it's very difficult to update and to improve it later on. And fourthly, harmonizing insolvency law is necessarily a patchwork and only really one element. And as the EU Commission was admitting itself, any harmonization of insolvency law can require far-reaching changes to other areas of law, like commercial law, civil law, company law, right? And so it's necessarily the problem that insolvency law intersects with many other fields like property, tax, labor law, and so forth. And the effect of how it's just one might be very difficult reaching out into other fields. Plus, we have still very strong differences in structure and role of courts and the judiciary more generally. So if we just harmonize insolvency alone, that really runs into the risk of remaining completely ineffective or even counterproductive.
Yes. So
final point. Yeah, I'm almost done. I'm almost done. Thank you. The final point in my critique is the enforcement problem, because insolvency law, as we all know, is heavily court-driven. And if courts or the enforcement procedure remains unharmonized, then again, the substance will not be very similar across the EU. And so we see this, for example, across the United States, where bankruptcy is a federal one, right? But the courts really take a very different approach to the same legal rules. That brings me to the 28th regime, because could that be a better alternative? I've already said at the beginning that in parallel to these harmonization efforts, there is this work on the 28th regime, which is, as you all know, now on the table as the EU Inc. framework. And the beauty of that approach is that instead of replacing and harmonizing national laws, it's sort of an opt-in instrument alongside the existing regimes. And companies can opt into the EU Inc., but are not forced to. And we've seen this already in other examples, like the SE, the Societas Europaea, which was adopted 25 years ago and has seen a mild success, I think, so far. Now, is that applying to insolvency law? Not really, right? So the EU Inc. is a corporate law regime, but it has some aspects of insolvency law. In Articles 88 and following in the proposal, there are some rules on a simplified winding up procedure, which is, however, confined only to innovative startups. So a subset of all companies, not to everybody. And that's a big definitional question as well. The simplified proceedings give you some sort of accelerated procedure with all sorts of nice gimmicks like digital communication and standard forms. But for example, there's no common agreement on what is insolvency. I mean, it's a cash flow insolvency, but it's left to member states to be fleshed out. And there's no consensus on questions like creditor hierarchy, for example. Funnily and ironically enough, many of these rules here on innovative startups are recycled from the draft harmonization directive, from the harmonization directive that I talked about earlier. And there were some parts that couldn't be agreed on at the time. And now they've been reintroduced in the EU Inc. context. But mind you, this is just the first step. I think the EU Inc. is really just one part of a broader 28th regime, and there is probably more insolvency, hopefully, or perhaps hopefully, a broader package to be expected. Now, is that a better way of doing it? It could be. Some people argue it's politically easier, right? It's easier to sell than a full harmonization because it's just an option, and member states can leave their national laws completely unaffected, unchanged. And that's easier than to accept for member states. I am a little skeptical about this argument because in reality, if we think about it, an optional regime like the EU Inc. is likely to be, the effects are likely to be similar to harmonization, because if it's attractive, then everybody will switch to it, right? And that will abandon the domestic system. So it will make the 28th regime de facto the standard. If it's not attractive, of course, nobody will choose it, and then it will be irrelevant. So if we anticipate this, that everybody will choose an attractive 28th regime, then the incumbents, the notaries and everybody else will, of course, object to any substantial reform, because that will undermine their incumbent position, just like any fully fledged harmonization. The other point is that many of the disadvantages of full harmonization that I talked about earlier on, finding the right standard and political agreement and all of this, apply in the same way here as in harmonization, right? There's basically no difference. Still, I think there are some small advantages. If, the political difficulties can be overcome, it's somehow preferable, I would argue, right? Because it's voluntary, and the decision to go to it will be left to the market. So it's not forced upon companies, but it's an option. It's some sort of regulated competition, not regulatory, but regulated. So it puts member states under pressure to update and to reform their national systems. And I think it's also great that they managed to choose the regulation as a legal form and not a directive, which gives at least some greater uniformity. Final point, the 28th regime is less dominated by domestic politics than any of the national options that are existing already today, right? You could argue, well, why do we need a 28th regime? Because you can already pick and choose any of the 27 countries at the moment. But the 28th regime is out of the hands of national politics, so that might have an advantage. And the other benefit, I think, is that arbitrage is there and less costly than moving the COMI across countries. So it can be a flexible EU instrument if it's done well. It can serve as a lab and experimenting with this as we go along. So a lot, of course, depends on the design and the future of any future regime. Is it opt-in? Is it opt-out? Does it apply to startups or midstream? And who's in charge ultimately? So drawing all of this together, I think EU insolvency harmonization is politically very hot potato at the moment, and everybody's in favor. I've tried to give you some warning signs here. I think the risks and downsides of this are frequently ignored, and one size usually does not fit all, fails all instead. And the 28th regime is a great concept. It has similar risks, but if I could choose between the two, I would go for the 28th regime and design it as an experimentation space. Thank you so much for listening.
Many thanks, Georg, for this insightful presentation. I think you raised many questions, also many interesting points. So I think that we can leave immediately the floor to the discussant, Irit Mevorach, University of Warwick. The floor is yours.
Thank you very much. Can you hear me well?
Very well.
Great. So thank you, Giovanni, and all the organizers of this timely workshop, and for inviting me to participate. Good afternoon from the UK. And thank you, Georg, for sharing your very interesting paper and presenting it so clearly. I will highlight some aspects of the paper, which I found particularly helpful and important. And while doing so, I will also add some of my own thoughts and comments on the paper and also on the EU Inc. insolvency element itself. So the article discusses the EU Inc. initiative and specifically focusing on the insolvency component against the broader backdrop of the EU harmonization in this field. And the first part of the paper takes us through the long road to insolvency harmonization and effectively situates that question within a wider ecosystem of pressures, both internal and external. And it links the history of insolvency harmonization attempts in the European Union and efforts to create EU corporate forms to major events, including the global financial crisis, Brexit, COVID-19, to highlight those pressures that have shaped both the drive to harmonize and the evolution of the EU harmonization instruments. It also highlights, and we saw that in the presentation, the pressures from international actors such as the IMF, the ECB, noting their calls for further harmonization of domestic insolvency rules within the EU. And I would add here another international actor not mentioned in the paper and in the presentation, and that is the World Bank, which in my view has been a major influence on the EU insolvency developments. And this is interesting, as it may suggest that harmonization has been driven as much by global competition and benchmarking as by direct external pressure. Until a few years ago, the World Bank had a powerful, though highly criticized and eventually abandoned, tool for incentivizing reform, that is the Doing Business Index, which included an insolvency indicator. And this connects to the 2015 Commission Action Plan, which noted that the EU member states' average score on the insolvency frameworks, as measured by that index, was below that of comparable OECD economies. And it further observed that those 2014 recommendations on restructuring and second chance had been only partially implemented, and therefore concluded that there was a need to move towards a legislative initiative, which suggests that the 2019 directive was at least in part driven by a desire to achieve a higher ranking in that Doing Business report. Now, returning to the paper, and against the backdrop of these pressures, the paper raises doubts about insolvency harmonization and examines those two directives, the 2019 Restructuring Directive and the 2026 Harmonization Directive, to consider whether, in particular, whether they might curb beneficial form shopping and constructive competition. And here, I would emphasize that conceptually, the two directives are quite different. The 2019 Restructuring Directive can be understood primarily as aiming to require member states to introduce restructuring procedures rather than to harmonize existing procedures. And the new directive, 2026 one, operates more clearly in the realm of harmonization or alignment of core aspects of insolvency laws, mostly already present in member states' laws, such as avoidance, directors' filing duties, creditors' committees, alongside additional elements such as pre-packs. And this distinction matters when evaluating the directives. The 2019 directive can, in my view, generally be praised for encouraging and facilitating the introduction of restructuring. The new directive, in seeking to approximate core aspects of insolvency systems, raises further questions, including why certain issues were selected for harmonization while others were not. And here I found the paper's contextual approach to the question of harmonization in insolvency particularly helpful and important, especially its emphasis on the need to take into account differences between the broader legal and economic systems of member states. And the example that Georg mentioned on avoidance law in the new directive and its similarity to relatively creditor-friendly German law is worth reflecting on, particularly how this approach may not be suitable for member states, especially those with more concentrated banking sectors and potentially stronger creditor power. More broadly, the paper's points about the benefits of competition and the risk that harmonization may limit constructive competition and beneficial form shopping are generally persuasive, especially in the context of restructuring and medium to large companies, which typically have the means and incentives to benefit from selecting sophisticated restructuring procedures and systems. I've made similar arguments in my own work, including with co-authors Stefan Madaus and Ilya Kokoring in our paper Global Competition and Cross-Border Restructuring, that we should recognize competition as a structural feature of global insolvency. But at the same time, I think that concerns about harmonization, curbing beneficial form shopping may be less acute in the context of smaller entities, which tend to require simpler, less sophisticated procedures, which brings me to the EU Inc. proposal, which is particularly geared towards a category of smaller, innovative startups and provides in particular a simplified winding up liquidation procedure aimed at facilitating low-cost exit for such firms. In a 2018 book on insolvency for micro, small, and medium-sized enterprises, which I've written with colleagues, we proposed a modular approach for MSMEs in distress that includes both simplified liquidation and restructuring with default and then flexible tools designed to be modular for jurisdictions to accommodate system differences and for creditors and debtors to choose from. Then in 2021, Ancitral published a legislative guide on simplified insolvency procedures for micro and small enterprises, which includes both liquidation and reorganization tools within a single integrated framework, allowing viable firms to reorganize and non-viable firms to liquidate within the same simplified procedure. Now, the insolvency chapter in the EU Inc. proposal also includes some degree of modularity, but this modularity is limited to procedural features within liquidation rather than extending to a choice between liquidation and restructuring. So the proposal is modular, first because it is optional. As Georg stressed, it doesn't seek to replace existing national regimes. It operates as a module in itself, offering a liquidation tool that can be opted into. And there is also some internal modularity within the insolvency chapter. It provides as a default that insolvency practitioners shall be appointed, but at the same time, it allows the debtor or a creditor or a group of creditors to request that no practitioner be appointed if certain conditions are met. And I find Georg's approach and evaluation of the proposal, particularly its insolvency component, very balanced here. There is a degree of cautious optimism that it could serve as a useful first step, providing a cost-effective option and potentially fostering constructive regulatory competition. The paper suggests that the 28 regime insolvency procedure may even have a self-correcting character. If it is unattractive or dysfunctional, it simply will not be used. The optionality provides a sort of inbuilt safeguard against a regulatory error.
Sorry, Irit, you have a couple of minutes.
Yes, exactly. That's perfect. So I generally agree with Georg's assessment. I would just add a further final note of caution regarding the focus on liquidation. So on the one hand, especially in the context of tech startups, it is sensible, I think, to enable and incentivize a quick and simple exit, allowing such firms to fail fast, move on, develop better ideas, while redirecting resources to new projects. What you want to avoid, though, is that the EU Inc. Regime ends up channeling innovative startups that are insolvent but still viable towards liquidation. So I'm thinking here in particular of tech companies in distress that may require additional financing and longer term, a longer time horizon, but nonetheless have a viable business model. And I worry that in such cases, the EU Inc. regime may incentivize quick liquidation rather than the use of simplified restructuring options. It may also sort of fail to do enough to encourage early and timely restructuring before startups reach insolvency at a stage of financial distress. And the 2019 Restructuring Directive and its implementation member states may not in practice provide a sufficiently accessible or visible pathway. Ideally, in my view, startups would have access to a single gateway procedure that combines both liquidation and restructuring in a simplified modular form. And while the point about self-correction is, I think, generally correct, it may be difficult in practice to assess whether the regime produces unintended effects, such as channeling firms towards liquidation in cases where restructuring might have been preferable. It is, in a sense, a road not taken problem, which is inherently difficult to observe and measure. So these were just a few comments or reactions to both the paper and the insolvency proposal itself. to reiterate that I found the paper very interesting and raising important questions worth thinking about. Thank you.
Many thanks, Iris, for your comments, for insightful comments. Maybe I will give the opportunity to Geo to briefly react to your comments.
Yes, I don't have a lot to say apart from thank you, Irit, for taking the time and for your thoughtful comments. I have one additional question, which I asked myself when listening to you. It's interesting, right? This accelerated winding up instrument, which somehow found its way into this EU Inc. proposal. Why do they put it in? I mean, your point is saying, I think that's a good point, right? It might, unintentionally limit the options. Of course, officially they say it's just one out of many. I mean, all the other national options remain on the table, right? But there's of course a strong sense that this might be limiting options. And the other question, Irit, I don't know what you think about this, is, would this simplified winding up procedure in the EU Inc. proposal also, shouldn't it be open to other firms as well? Why should it be limited to EU Incs, right? I mean, as it is constructed at the moment, it's part of the EU Inc. legal framework, which is a corporate legal framework, but it doesn't seem to be open to anybody else. And that somehow is also contradictory in itself. So, I mean, I don't really have any great answers here, but it's just questions.
Many thanks. I think that we have 5 minutes more or less for a couple of questions from the audience. Of course, you can raise your hand. Otherwise, if also Irit wants to add something, or
I would just add to Georg's wondering. I think the first wondering is what happened in the previous draft of the harmonization directive, right? Where they focused on winding up of MSCs. Because as you said, exactly, because as you said correctly, that eventually ended up, I think, quite abruptly within this regime. And I think maybe at the end of the day, I want to say something positive here, because I think maybe what you need to do is something incremental, right? So get it through, but then relatively quickly move on to a second step. So monitor what is happening speedily, and start thinking about filling in some additional gaps. And I would say that the first one is, what about restructuring? Because yes, as you said, this is not the only option, right? And it's alongside the restructuring directive and national laws, etc. But my worry is about, and I think you agree, is about a liquidation bias. Once you have your regime, I'm the EU Inc. What I see is liquidation. I may just use it too quickly.
I see that there is a question. Julia Told, please.
Thank you very much. My name is Julia Toll, and I'm from the University of Innsbruck, and I'm thankful for these two very instructive speeches. And I understand that the insolvency rules by the EU Inc. proposal are limited to be chosen by innovative startups. And these innovative startups might have a more homogeneous capital structure than other companies. And could a harmonized approach be more likely successful due to this fact? But then we have to ask ourselves what really makes an innovative startup, and we lack a definition here. And I would wonder what's your perspective on these questions. At least, most likely, there are two questions. Thank you so much.
Right. Yeah, I think that's a fair point. Right. So by limiting it to a subset of EU Incs., not innovative companies, but only innovative startups. So basically it's two categories down. They have all EU Incs. And then innovative companies and then innovative startups. And undoubtedly there will be lots of discussion and litigation around which category you fall in. So I'm rather skeptical on whether this approach as a whole is sensible or not, to predefine criteria, number of employees and turnover and years of existence and all. But all of these concerns aside, I think your point is well taken, that at least limiting it to a subset makes it likely that a common approach is probably more likely. Still, I think my point that the creditor structure remains heterogeneous across the EU remains. I mean, the funding needs of those innovative startups may be slightly similar, I take it, but the business realities in which they operate will still be quite heterogeneous.
Maybe there is just the last question in the chat. I don't know if you can see it, but the question is, would be interesting to assess the possible impact of the EU Inc. on the EU financial integration and deepening. Could it lower the cost of funding for new companies, startups with less collateral? That's the question. It's a quite broad question.
Yeah, I mean, in a way, that's the $1 million question, right? So will this help that the companies stay here in Europe and don't flip over to Delaware? And in a way, I think this sort of also emerged in the first paper discussion, and I also wrote about it. I think the EU Inc. proposal is great for startups, right? So digital and quick formation and all of this is something that founders like because they don't like to have the bureaucracy. But the real question is whether the VC industry will subscribe to it and whether they find it acceptable or not. And VCs are not interested in whether the incorporation happens in 1 day or 2 days, right? And these things, they really want to have a predictable legal regime. They want to have one certain legal regime and not 27 different flavors. And the EU Inc. proposal, as it's on the table at the moment, makes these references to national laws. That's a problem, right? And it still leaves, the insolvency options untouched, right? It induces, as Irit was saying, one option which seems to be highly suggestive now that this is the default. So go for the liquidation, which isn't everything, right? So the national insolvency procedures will be there, and the heterogeneity will be there as well. Last point, if I understand the European Commission well, EU Inc. is really only one part of 28th regime. 28th regime is much larger, and they will produce more. They promise to produce more in other areas, including insolvency. So wait and see what's coming next.
Yes, thank you very much. There is also another comment in the chat by As the Wolf that is less optimistic. According to him, there is nothing in the proposal that can facilitate or lower the cost of capital for the VC funding. But we will see. I will say I am not so optimistic, but I thank you very much, Georg and Irit, for the presentation and the discussion. We learned a lot from both of you. Now we have a short break, 15 minutes. We will start the second part at 2:40, so we will reconvene in 15 minutes. Thank you very much to all of you.